Hi, it's Roland Jones. A warm welcome to my slideshow. I hope you enjoy it. Well, I've been representing preference defendants for over 15 years now, and typical scenarios like this. You deliver a product or render a service to a company, you get paid, everybody's happy, and then about 2 years later, trustee sends you a letter or files a complaint, and he wants the money back. But by the way, he doesn't want to, he gets to keep the bankruptcy estate, gets to keep your product or the benefit of your services. So the reaction I get from clients is, uh, how could this crazy law exist? Well, this just doesn't make any sense. It's not fair in any sense of the word. Roland, why do these laws exist? So I typically gave pat answers, and after hearing these bitter complaints enough, I decided I'm going to do my own research and find out, well, why do these laws exist? What is the reason for the laws? And maybe, where did they go wrong, and how should they be changed? So I kind of swam through oceans of law review articles and spoke to a lot of people, and I'll try to summarize it as best I can based on my research. So the first thing is, what are we trying to solve here? What's the basic problem that we're trying to solve? I think the easiest way to look at this is that it's a party. It's a party that a lot of people are invited to. Um, and the problem is, some people get there early. So what's the advantage of getting there early? How's that relevant? Well, let's say, four people show up early, and the hostess puts a nice pie on the table, and these guys split up the pie evenly and start taking pieces. The problem is, it turns out that this is a much bigger party, and 100 people show up an hour later, and 100 people have to now divide up either half this pie or 75% of this pie into tiny, tiny slices. So some of these people that came later start to grumble and say, how come these guys got huge slices where we had to all get tiny slices? Not really very fair. And so they start complaining to the host, and the host says, look, there really, there are a lot of people that have to divide up this pie. So I'd really like you to give back the pieces that you took, so we could divide this up evenly, so nobody gets upset. Well, there are all kinds of issues that come up now. I mean, one guy says, "Well, what do you mean I have to give back my slice of the pie? You crazy? First of all, I already ate it, and why should I have to give it back? I didn't know there were going to be people showing up. It's your fault." What if one of the guys came there purposely to get a big piece, and he knew there were going to be a lot of people at the party, and everyone finds out? Should he have to give back the pie? What if these four guys? What if there's no pie left at all? It's all been taken, and there's nothing for these 100 people that show up on time. Should it should Is that a stronger argument for having these guys give back slices? What if only one slice was taken? So can we live with that and let everybody else divide up 75% of the pie? So there are a lot of issues that come up at this party. Well, if you substitute the host for a trustee, bankruptcy trustee, or creditors committee, and you substitute the start of the party for the bankruptcy filing date, you pretty much have a definition of what a preference clawback is all about. What's interesting is that preference clawbacks are not really defined in the bankruptcy code. The bankruptcy code only defines certain transfers, certain payments that can be avoided, taken back, or not. This is 547B. The trustee may avoid any transfer of interest of the debtor in property, and it gives a sort of a laundry list of what the trustee has to prove so that he can avoid a transfer. 547C tells you situations where the trustee may not avoid a transfer. It doesn't say that there was a preferential transfer. It doesn't even use the word preferential. It just says what the trustee may or may not avoid. This is my own definition of what a preference is. It's probably a gross simplification, I'm sure it is. But it's like the party. Any full payment to a creditor, a full slice, when the debtor is insolvent, when there are a lot of demands on the pie and the debtor can't pay everyone a full slice. The pie's got to be divided up a lot smaller, followed by a bankruptcy. Start of the party. Okay, well, I sort of hinted by my story what the rationales are for the preference clawback laws. But I'm going to go into each one of them separately, and then we'll take a look. Do these laws meet their goals, or do they need to be changed? Well, I kind of touched on this. So during the pre-bankruptcy period, the debtor is insolvent. He can't pay anyone in full. There's not enough money to pay everyone in full, and yet some guys are being paid in full, and it's not fair. And then when there's a bankruptcy filing, the other unfavored folks get to split up what's left. So there's basic unfairness, and we're going to try to fix that with the preference laws. We don't want to reward creditors from being aggressive at first to the courthouse. In other words, we don't want to reward them for being first to the party. That's the opposite of what we want to do. And the preference laws, in theory, these folks will know if they're aggressive while the debtor is insolvent right before bankruptcy, they're going to have to give back the money anyway and go through a lot of hassle. So they're going to be less aggressive. Also, we want to discourage these guys because maybe these troubled companies won't need to file bankruptcy at all. So this sort of discourages aggression during this chaotic, vulnerable pre-bankruptcy period and stops rewarding people from getting rewarded for being first. I know I'm mixing metaphors, but I can't help it. I really like this metaphor also. Game of musical chairs. The guy that knows that the music is about to stop, he gets advance notice, he's going to get a chair, or those folks are going to get chairs first, and the other guys are going to be left without chairs. So it's not fair. Look, if I know that there's a level playing field and those guys that are running to take advantage or get there first, they're going to have to give back their slices, I'm more encouraged to do business. So I'm satisfied that this is a fair and open environment protected by the preference laws. This is sort of like rationale number 3. Hey, I'm doing business with the debtor. I know it's a troubled company, but I know after a filing, we're going to look back and look under rocks, and I'm protected from these secret sweetheart deals. There's not going to be anyone siphoning out the assets of the debtor, so I'm safe to extend credit. Well, the rationale here is we don't want all this money flying out the door right before bankruptcy, right before we're about to start to distribute these assets fairly and equitably. The preference laws either will prevent that by discouraging creditors to rush to get paid or rush to the courthouse, or will discourage creditors from being aggressive. So less money is siphoned away from the debtor right before the bankruptcy and right before there is an opportunity to distribute all these assets in an equitable way. Rationale 6 is, we're going to do all these great things, but we're not going to disturb ordinary trade. In other words, some guy shows up early to the party, they shove a slice on his plate, and he doesn't know anything about people coming later, and he didn't ask for the slice. He just happened to get it by accident. So we're not gonna prosecute this guy. We're gonna let him keep his slice. Well, I have to say there are some problems in practical application of this law. It's basically a train wreck, and I'll go into why. Before I start disputing the rationales and show why they hold no water, I want to talk about retroactive application because it's a very serious negative aspect of the preference laws. The preference laws come into effect on the petition date. It's basically a new law. It's a change in the law. Most changes in law are forward-looking. In other words, the law changes, the legal landscape has changed, everybody knows it, so you can change your conduct. But the preference laws change the past. They go back and change the past legal landscape. So what do I mean by that? The standard creditor law is race to the courthouse. You're encouraged to be aggressive. The more aggressive you are, the faster you're going to get paid, and you get first dibs on the creditor's assets. That no longer applies during the preference period. When the preference laws are in effect, the law is be patient, wait in line. There's a line that's about to form. Don't be aggressive, and otherwise we'll have to sue you and get back the money. Let's say you're managing a troubled company and you can't pay everybody. One of your creditors say, hey, if you pay me everything you owe me immediately, I'll extend credit. Instead of 60 days, we'll make it 90 days. So you decide to favor that creditor. You're going to pay that creditor first, everything that you owe them, so you get a special deal. No, you can't do that. Under state law, you can do that. It's your property, or you're authorized to manage the company. But under the preference laws, which are suddenly in effect without your knowledge, because you don't know you're in a preference period, these decisions are going to be reversed. You can't do anything you want with your property under the preference laws. Take the same example as before. A creditor says, hey, you pay everything you owe me now immediately, and I'll extend credit 90 days. So you're entering into a deal with this creditor. It's basically kind of contract. You're paying them now. They're promising to extend terms. And under state law, you can do that without a problem. But if you're in the preference period and the preference laws are in effect, that's going to be reversed probably as a preference. So a contract that you entered into is going to be reversed. It's null and void. So the law is reversed with no notice. So you might say, Roland, hey, these guys know there are preference laws. What do you mean there's no notice? Of course there's notice. Everybody knows that after a company files for bankruptcy, creditors might be sued for preferences. Well, there's no notice, and there can never be notice. Why? Because no one knows when the bankruptcy is going to be filed. So no one knows when the preference period is going to begin. It's impossible to know if bankruptcy is going to be filed. And why is that? Well, let's be candid. No troubled company is out advertising it's about to go bankrupt. It's just the opposite. Companies are telling vendors, hey, we're about to get a new, things may be a little bit slow right now, but hey, we're about to get a new customer. We're about to get new financing. We have a turnaround plan. So vendors don't know that there's a bankruptcy about to be filed. It's impossible for them to know that or predict that with any accuracy. The other thing is there could be a change in circumstances. In other words, maybe the company is getting new financing. Maybe things are terrible and it looks like they're heading for bankruptcy. But they get a new deal, they get new financing, business gets better, there's a new hot product. The point is, no one can know for sure if there's going to be a bankruptcy filed in the next 2 or 3 months. And so no one knows that they're in a preference period because they don't know there's going to be a bankruptcy filing. This is pretty obvious. It's just unfair to have a different set of rules that you don't know about suddenly apply without your knowledge. Sir, you were doing 60 in a 20-mile-per-hour zone. Officer, I just passed a sign a couple of miles back saying the speed limit was 60. The officer says, well, that's changed. It became 20. And you say to the officer, well, when did that happen? I didn't know that there was a sign. I didn't see any sign for 20 miles an hour. The officer says, well, it's a couple of miles up ahead in the road. That's why you haven't seen it yet. Okay, so it's retroactive. So maybe it's still worth having. You have to balance the equities. So being retroactive active is on the negative side of the scale, but maybe it does a lot of good this law. So let's look at the first rationale: quality of distribution during insolvency. So, to go back to our story, we're going to take these huge pieces that were taken before the party started, and we're going to take them back, and we're going to cut the pie up in a fair way so everybody gets an equitable slice. So we're going to take the money back from unsecured creditors that got paid 100 cents on the dollar while the debtor was insolvent. We'll take that money, we're going to put it in a big pot, and we'll split it up fairly among all unsecured creditors during the bankruptcy case. Well, the first huge problem is that unsecured creditors don't get the money. The money is brought back into the estate, yes, but it doesn't go into a pot for unsecured creditors. The funny thing is that there is no law that requires that the money that's recovered or avoided from unsecured creditors, that money has to be paid to other unsecured creditors. In fact, the opposite usually happens. Usually this money goes to pay secure creditors or it goes to pay administrative expenses. That's right. The lawyer that's suing you is getting paid with the money you're paying. Actually, it gets even worse. The amount of money available to each unsecured creditor actually goes down because of the preference laws, because of these clawbacks. So why is that? Well, a creditor that's forced to return a transfer has what's called a 502H claim for that same amount against the bankruptcy estate. So I'm just going to read this. So not only do unsecured creditors rarely receive the money that is avoided, the amount of money in the unsecured creditors fund needs to be divided by yet another creditor. Who's the new creditor? The creditor that just had his preferential transfer avoided. He's the new creditor, but the transfer does not go into the pot. Another way of saying this is back to our story. There are more people eating. The new guys that came, the guys that came early, they're now also eating what's left of the pie, but it's the same size pie. The missing pie slices are not being returned. So you have more people eating and the same amount of pie. Not to beat a dead horse, but you have 4 creditors after the bankruptcy is filing. They're each going to be paid $25K from $100K in assets. No new assets are brought in, even though money is avoided from an unsecured creditor who got paid in the pre-petition period. But you do have a new unsecured claim of $25K because that's what was avoided. So and now what everyone is going to get is $20K because it's being divided 5 ways. So a law designed to help unsecured creditors, or what appears to be designed to help unsecured creditors, actually hurts them. Another reason that the equality of distribution rationale is problematic is that often most, if not all, creditors are sued in the 90-day period. If all or most creditors are paid in the preference period, how can any one creditor be preferred? Can all creditors be preferred, or most creditors? Just doesn't really make a lot of sense, does it? Reason number 3, why the equality of distribution argument does not make sense. Not only do the preference laws actually make things worse for unsecured creditors, but they actually create a new class of preferred creditors. There's some VIP party attendees who form a preferred class, and they actually get to keep the big slices that they took during the preference period. So while unsecured creditors who are allegedly preferred have to give back their slices, these guys get to keep the big slices. So who are these guys? Well, those creditors that are accepted from the preference laws are the special guests at this party. Creditors that are accepted under the contemporaneous exchange exception, COD creditors, pre-90-day creditors, and my favorite, secured creditors with new liens that are actually placed for the first time on new property during the preference period. Well, contemporary exchanges are essentially COD transactions. You buy bananas, you pay cash, you get your bananas. There's not a credit transaction. No credit is extended. And the theory is, well, the debtor is getting immediate value for its cash. So there's no diminishment of the estate. The estate's not being diminished in the 90-day period because although cash is going out, it's getting immediate equivalent value, in this case, bananas. But the exemption really doesn't make a lot of sense because creditors that extend terms, that extend credit, they're providing a valuable service or a product that the debtor is paying for. The debtor is still getting value for its money. What's the difference if it has terms? It's actually better for the debtor if it has terms. The other argument is that you're rewarding people who are demanding COD payment. In other words, you're rewarding the exact kind of pressure that we want to discourage. We want to reward creditors that are extending credit, not less credit, more credit. We want to reward creditors that are lengthening terms, not people that are coming in and demanding COD payment. So why is there an exception for these people? It doesn't really make any sense, and it's arbitrary. Why exempt transfers over 90 days when the debtor is insolvent in that period? Let's say the debtor has been insolvent for 6 months. So creditors that get paid in full on the 91st day before the bankruptcy, they're exempt, while creditors that are paid in 90 days are exempt. And what if those creditors over 91 days, what if they're in cahoots with the debtor? What if they know there's going to be a bankruptcy filing? It doesn't matter. They're completely exempt anyway. I think it's an arbitrary period of time. I think the period of time should be, if anything, it should start when the debtor is insolvent. That's when you have the pie issues that we were talking about. 90 days is a completely arbitrary period of time. Secured lenders with security interests in assets that are turned over, such as inventory or receivables, often have clauses and arrangements that these guys get brand new liens on new receivables and new inventory. And this could happen during the preference period. So you have a situation where secured creditors are actually getting new liens and locking up the debtor's property during the preference period. They're getting transfers. They're getting new transfers during the preference period. I don't see how it's fair to exempt these people, especially since who is more likely to have knowledge of an upcoming bankruptcy and the debtor's troubles? A trade creditor or a secured lender? Obviously a secured lender. They demand a lot of information. My guess is if anybody knows that a bankruptcy is about to be filed, it's the secured lenders, and they don't really care because they're getting new security interest. They're fully secured going into the bankruptcy. I don't see that it's fair that they get accepted. Lawyers watching this video are going to say, well, there's a special provision in 547 that regulates how these guys are paid. But the fact is, if you do a case law search, you'll see that that provision really doesn't protect unsecured creditors. It's extremely rare that it's used to claw back money from secured creditors with after acquired liens. It's not effective. Okay, rationale number 2, let's see if this works better, is that the preference law discourages creditors from being aggressive because they're aware of the preference laws and the possibility of having their transfers avoided. Well, does this work? Unfortunately, no. The main problem is that creditors don't know when there's going to be a bankruptcy. That's only in hindsight. that there's a preference period. When you're doing business, you're just doing business. You don't know if there's going to be a filing or when it's going to be. So it just doesn't make sense for a creditor to just say, oh, well, I might be in a preference period because there might be a bankruptcy 2 or 3 months down the road. So I'm not going to act aggressively. It just doesn't make any sense. Even if a sophisticated creditor knew for sure that it's in the preference period, it's always better to collect money than not, because a sophisticated creditor is going to know that these cases are usually settled for pennies on the dollar. So why not get 100 cents now and then maybe have to give back 25 cents or 50 cents? It's much better to do that than do nothing and get paid 3 to 5 cents after a bankruptcy filing. The third rationale that I mentioned was helps troubled companies by encouraging business with troubled companies. The theory is the playing field is more even, but the truth is that the preference laws actually discourage vendors from doing business with troubled companies, even if they think there's going to be a filing. Why is that? The reason is that the way the law is currently structured, the main defense to a preference case, the ordinary course defense, actually discourages and punishes workouts. I'll tell you why. The ordinary course defense is based on a comparison between a historical period and a preference period. It basically rewards consistency between these two periods. And the theory is, well, if there's consistency, then what happened during the preference period is ordinary, because it's like the base period. The problem with that is that, let's say a creditor is being paid on 30-day terms in the historical period, and then all of a sudden, during the preference period, it's being paid in 90 days. But why? Because it extended terms, because the debtor's in trouble. So the creditor is extending terms to help the debtor, and it does help the debtor probably. And at the same time, it's destroying its own ordinary course defense. So, if any vendor knew in advance, not many do, but if a vendor knew in advance of the preference laws and the ordinary course defense, the last thing a vendor is going to do is going to want to change anything during the preference period. So it's certainly not going to agree to extended terms, because that would destroy its own defense. What's encouraged, like I said before, are super short terms or COD terms that would fall under the contemporaneous exchange defense. But this is exactly what hurts the debtor. The debtor needs credit. It doesn't need to be pressured into COD transactions. So the preference laws actually reward creditors with leverage, those that can demand COD payment, and who are not extending credit, and hurts those who want to help the debtor by extending terms, workouts, and that kind of thing. The next rationale is that there's more transparency. Actually, there's not. There's more secret stuff. I'll give you some examples of what is kept from unsecured creditors. First of all, it's kept from unsecured creditors. I mean, the standard rationale, anytime a client asks, why do you have to pay the money back? The answer is, well, the reason is to redistribute among unsecured creditors. So there's a little secret number one. That doesn't really happen too often. Also, creditors tend not to be sued until a couple of years after the bankruptcy case. And one of the reasons for that is the debtor is just getting out of bankruptcy post-petition and needs to do business with these vendors. I don't know how honest that is. I think they should be told that they could be subject to preference lawsuits, but that's the way it is. Also, during the preference period itself, the debtor often encourages workouts. Granted, it's the management of the debtor, and maybe the management is not aware of potential preference lawsuits, but the fact is, workouts are encouraged. Where does the money go? I've already covered that issue. The other thing is that case settlements are often secret. Um, in a public proceeding where multiple defendants are being sued by the debtor, it would seem to me that that should be public information, and it's important to defendants. But a lot of times, those settlements are confidential. I sort of covered this during the preference period. No one tells the vendors that they're going to be sued for the goods that they're delivering, goods and services, that they're actually never going to get paid for those. I think it's sophisticated, big cases where planning for a bankruptcy, at least contingency planning, is going on. I think it's, I would say, just sleazy for vendors not to be told that the goods and services that they're providing right before a bankruptcy filing that somebody's got to know about are probably going to either not be paid for or at least partially not be paid for. Rationale number 5, prevent diminution of the estate. Well, I think that's the case. Actually causes diminishment of the estate. It doesn't really make sense that the estate is being diminished because it's paying out debts to unsecured creditors during the preference period. You have to look at the transaction as a whole. The debtor bought these services, bought these products, or paid for these services because these things generated a profit for the debtor. There's no other reason to buy goods. So not only did they get the goods at the price they bargained for, but it augmented the estate because they earned a profit from these transactions. So it's not a diminishment at all. What happens in a case of an avoidance is that other creditors, other entities in the creditor body obtain a windfall because the debtor just got goods and services for free that it sold at a profit. So it's really a windfall, and it also discourages business with troubled companies so that there's less profit. I mean, if it does anything, it discourages vendors from doing business in this period. Well, there's some problems with the preference laws, you might say, but the fact is it does bring some money into the estate, so maybe it's better than nothing. The problem is the amount of disruption these laws cause, and I call this the triple whammy. First whammy, typically a creditor doing business with a troubled company that files for bankruptcy, first is not going to get paid. Often does not get paid before the bankruptcy, and then after the bankruptcy, it doesn't get paid either. And then it gets a clawback. The second whammy is the clawback for payments it did get for goods and services. So don't forget, typically creditors are not paid either during the preference period for goods that they've supplied previously, or for goods that they've supplied during the preference period and they're not paid for. So typically there's a claim against the estate. That's the first whammy. Second whammy is they got to give back the money for goods or services for which they were paid. So that's the second whammy. The third whammy is that typically bankruptcies occur in depressed industries, so that often the vendor is also hurting for business. It's not a good time for either the debtor and often the vendor. Often the vendor's other customers are in the same business as the debtor, and so business is not good, and they're not being paid, and they're being sued for preferences. And if they go bankruptcy, they're going to sue other people for preferences. And it's a gift that keeps on giving, and the end result is a more depressed economy. Well, the other issue is, is it just wrong for some creditors to be preferred, to get sweetheart deals, or just to be preferred? And the answer is not always. I think it makes sense sometimes for a debtor to prefer a particular vendor especially if the vendors, like I gave an example earlier in the video, vendors willing to extend terms. Why wouldn't you possibly not want to prefer that vendor is willing to work with you as opposed to a vendor who's, for example, demanding COD payments? Another situation would be, let's say it's a critical vendor. Let's say you're in the restaurant business and you're in the seafood business, and your seafood supplier is refusing to provide product unless you get caught up on the payments with him. Does it make sense to prefer that vendor among other vendors? Yeah, I think it does. You have to stay in business, and this happens to be a critical vendor, so it makes sense. But in a preference case, the rigid statute replaces a manager's judgment on how to run his business. What is the real issue messing up our preference laws? How can we fix these laws, and what's the number one problem? The real issue. The biggest problem is that we sue innocent vendors that do business in the ordinary course. The ordinary course defense that we have is extremely narrow. It just applies a rigid comparison between two periods. Most vendors that get what I call accidental preferences, in other words, they did not know there was going to be a bankruptcy filed, and the financial circumstances of the debtor did not motivate them. They simply want to get paid, paid in the ordinary course. It's these vendors. It's suing these vendors that is the biggest problem. Like I said earlier in the video, using the party example, it doesn't matter. If you're early to the party and you're getting a bigger slice, whether you knew other people were coming later, whether you had bad intent, whether the host decided to make you a VIP, it doesn't matter. You're being preferred. So it's important to understand that any protection for vendors during a period of insolvency is not implying that these vendors or creditors are not preferred. They were preferred, but we've decided to make an exception for them. I believe there's a strong argument for exempting all accidental, unintentional preferences. And what is that? Well, to go back to the pie and the party, the guy that walks in early but really doesn't know there are going to be other guests, is not aware of any kind of preference, and someone hands him a plate with a slice of pie, he eats it. I think that's an accidental preference. What's really unfair, I think clearly unfair to everybody, is a conscious scheme to get a bigger slice. And so what does that look like? Well, let's say, and continue with the party example, the host intentionally favors certain early guests. So everyone's going to the party, but there's a conscious scheme that early guests or certain early guests should get a much bigger slice of a limited pie. I think if I were one of the 100 guests, I would find that to be very unfair. Another example is a guest intentionally schemes and knows if he shows up early and grabs a slice before anybody else shows up, he's going to get a big slice. I think if everybody knew that was happening, that was an intentional scheme, I think everyone would agree that that's wrong, that's morally wrong. It's unfair. I think it's just common sense that an intentional scheme to favor certain guests is unfair to the other guests. The point I'm trying to make is that there is unfairness with a conscious scheme, and at the same time, people are still getting preferences. If I show up to the party and I get a big slice, even though I don't know it, even though no one intends it, it doesn't mean I'm not being preferred. I am being preferred. And the same thing in a bankruptcy case. If I'm getting a payment in the preference period, but there's no conscious attempt, there's no intentional scheme to get an advantage, I'm getting a preference. But the point is, I think we should fight bad actors, not preferences. I think that's what's really unfair is a conscious attempt. The main point is that bad actors have notice by definition. In other words, if there's a conscious attempt to get an advantage, then that person is going to know that 100 people are going to show up. That person is going to know that a bankruptcy is about to be filed. That's the definition of a conscious intent. So there's notice is not an issue there. That person knows there's going to be a filing. So theoretically, that person should also know that there are preference laws in effect. That's not true for accidental preferences. Vendors that don't know there's going to be a filing, don't have a conscious plan, don't have notice. And to me, that's a very serious problem. So focusing on willful, conscious, bad faith, successful attempts to get preferences cures the notice problem. A big fear is that all the assets of the debtor will be siphoned off in preference payments prior to a filing. So why is that bad? Because why have bankruptcy law at all if that's going to happen? Because there's nothing left to distribute. The entire, well, I would say probably the main purpose of the bankruptcy laws is to make sure that there's fairness in a situation of insolvency. That danger doesn't really exist with, theoretically it could happen with accidental preferences, but it's more likely to happen with an intentional scheme to siphon off assets, knowing that there's going to be a bankruptcy. I would think that that's more of a danger to the bankruptcy laws than occasional accidental preferences. And also there's a moral issue. It's simply wrong for people to have knowledge of a bankruptcy and intentionally flout the bankruptcy laws, intentionally game the system. That's what we should be focused on, not the occasional accidental preference recipient. Well, these are the benefits of requiring bad intent. Requiring the trustee, and I'll be more specific, requiring the trustee to prove bad intent. First of all, it does away with the terrible notice problem because the bankruptcy is known by the bad actor. The law is a lot fairer because the focus is on bad conduct. Intentional gaming of the system is punished, but not innocent, real ordinary course transactions. And when I say real ordinary course, not just transactions that are consistent with the prior period, which is an extremely far too narrow definition of ordinary course, and it really doesn't comport with reality. What's interesting is that past laws required proof of bad intent. Throughout the history of the preference laws, which I'm sure everyone is excited to learn about, the laws fought bad actors. That's what they did. Don't go to sleep on me. The first preference law was actually enacted in the time of Shakespeare, and then it wasn't changed until 300 years later. In other words, the obligation of the trustee to prove bad intent was taken out in 1978. So for 300 plus years, there was an intent requirement. Okay, I couldn't help it. This was the first preference laws. Shakespeare was active and in the theaters. And this Queen Elizabeth was queen. Couldn't help doing that. What I found interesting is that the punishment for a preference was to put someone in this thing, the pillory, and cut off one ear. So that was the fine for an intentional preferential transfer back in the age of Shakespeare. Which makes me wonder, were they right to focus on intentional prejudice? I think maybe the punishment was a little bit extreme, but I think they were right to focus on bad intent and bad actors. The other thing about criminalization of the preference laws is it's a real deterrent. Maybe having to give back some of the money is not a deterrent. We've already talked about that. It's clearly not a deterrent. But having to give back 3 times your preference and maybe having criminalization make it at least a misdemeanor, maybe even a felony for large preferences, will certainly be a deterrent for an intentional preference. They can keep their ears, but I think they should pay. Yeah, I already said that. Well, I think that's true. Replace the true deterrence with an arbitrary and unworkable mechanical test. The ordinary course defense just doesn't work the way it's set out now. It's arbitrary and it doesn't really make a lot of sense. It doesn't accept ordinary course transfers or accidental transfers. It accepts a very, very few who had the luck to be paid consistently. Well, that's my opinion, and I'm sticking to it. Okay, so a lot of lawyers out there are going to say, well, the reason we changed the law is we don't want to give the trustee the burden of proving intention again. That was the problem that we solved. Otherwise, he's not going to, if he has to prove intention, he's not going to recover anything because intention is very hard to prove. Well, if we specifically permit circumstantial evidence, either in statute or by case law, it's going to be a lot easier for a trustee to prove intent by emails, by the circumstances of the transaction. I don't see that as an impossible burden. In fact, we already allow intent as one of the elements in a contemporaneous exchange defense. That's one of the elements. I don't think that's proven to be such a burden. Most courts allow circumstantial evidence. There's also an alternative paradigm that I might suggest. Insider trading laws. It's actually, the insider trading laws address a problem that actually is very, very similar. Taking advantage of others by intentionally using secret knowledge in advance of an event. That's what an intentional preference is. We're getting an advantage because we're in the know. We have secret, non-public information, and we're using that to get a preferential, to get a big slice of the pie. Even if we don't want to change the laws entirely, the laws should be, I think, drastically amended to require a proof of intent on the part of the trustee and to focus on fighting bad actors, not preferences. Preferences are going to happen. It's just the way it is. But we don't have to put up with intentional, willful preferences. And I think we shouldn't. Just not to beat a dead horse, but it also satisfies the need for justice, which is one of the requirements of a good law. I don't think anyone would find it fair for someone to intentionally get a bigger slice through a scheme, or to get more, to get a much higher distribution because of insider knowledge. That's inherently not fair. The rest I talked about in prior slides. If we're going to focus on fighting bad actors, we need to do away with the 90-day preference period. First of all, it's arbitrary. Uh, and second, we're leaving a lot of money on the table. Any intentional preference with knowledge of a bankruptcy after insolvency should be avoided, and there should be triple damages, and I think some criminal liability. There's no reason to cut it off at 90 days, especially if we're focusing on intentional bad faith preferences. Also, there shouldn't be any exceptions for cash on delivery, for after acquired property liens, or for anything else. There's no reason to accept anybody. What we're fighting is an intentional bad faith attempt to cut to the head of the line and get a bigger slice. There shouldn't be any exceptions whatsoever. Again, these exceptions leave a lot of money on the table. A lot of lawyers are going to say, well, the estate's going to have is going to have much less income from these preference cases. I think the estate's going to have more income if we take away the exceptions and focus on bad faith dealings. Well, that's all I have. A lot of this slideshow is my own opinion. I'm just going to repeat that, and obviously there's no specific legal advice. But thanks for watching.